from Caroline is asking, good evening, I need advice on a development. The property was bought in 2020 and obviously directly from the developer, and from what I'm seeing, it's probably an off-plan purchase. They moved in then in December 2021. Prior, which is why I'm saying it feels like an off-plan thing, because if they bought 2020, December 21, taking occupation sounds about right. Prior to moving in, I made the agent and the transfer attorneys, told them that the property was incomplete. I was promised that it will be completed in the next 3 months. Till today, nothing has been done. Worst case scenario is we now don't have electricity. We are using a generator that goes off and on at different times. The municipality of city of Tshwane came 3 months ago to switch off the builders' powers. We were promised again by the developers that the matter will be resolved. Still waiting for water meters. We're not even sure whose water we're using. Please advise, we are tired of everything. The developers, the agents, the transferring attorneys are no longer responding to emails.
Wow. Okay. So yeah,
I'm gonna keep my face straight.
Are you gonna try? I might swear somewhere along this answer.
Even right. Me, and I'm not even answering. I'm just grateful you got this question.
So yeah. So look, the problem that we're experiencing, and I've noticed it happen quite a few times, is the credibility of the developer is crucial. So to anyone watching this, except obviously Caroline, which I'm really sorry for your experience, but anyone other than Caroline that's looking at buying into developments, be very careful. Credibility does play a huge role, which is why if you're buying off plan and you're actually getting funding from the bank, more often than not, the banks actually require the developers to have a certain amount of credibility before they're even willing to fund in a development involving that creditor. So just bear that in mind. So I'd love to know what happened here and why the bank seemed comfortable to finance you if the bank did finance you. I know that remember the bank also carries a certain amount of security in the property, given that the mortgage bond is registered over the property. So your one partner with certainty here is going to be the bank. If you did get funding through the bank, because the bank does not want to derelict body corporate, knowing that if you stop paying your bond right now, yes, you'd be liable, but the security that have over you is irrelevant. So I would, for starters, just for the sake of support and almost like a shared resources basis, go to the bank and let them also start pushing and prodding and figuring out what's going on, because they might know more about this developer than you do, right? That's just a practical piece of advice. Now, if you're all alone and you're trying to figure this out, there's two distinct different problems here. We're speaking about incomplete property. Now, that is a contract that you have and a mandate for construction. Very often you'd buy the property off plan. There'd be a construction contract. So you'd have a claim, not necessarily against property owner. Even if it's the same, you'd have a claim against the people building the property and giving it to you to spec, right? So that is a contract that you need to enforce, and it seems very factual. So if it's simply a question of incomplete as opposed to defective, it's two different answers. A defective property means they completed it, they just didn't do a very good job in completing it. And then you could always go to the NHBRC, for example, to lay a complaint. As to the defects, you can get a quote from an outside third party, how much it's going to cost to repair, and you're going to go for it. Remember, NHBRC does have very tight time frames when it comes to your ability to actually go lay complaints. So if it's defects, go quickly, lay the complaint and start running with it. If it's just purely incomplete, it means the contract wasn't completed. So you would have to, unfortunately, have a direct claim against the developer. And that would be a litigious matter of compelling him or getting somebody else to do it and then trying to claim it from him, right? Depending on the seriousness of the incompletion, like you don't have a roof, that's big. If it's something small, you could probably have a little bit of time to play around with to demand and stuff like that. The fact that there's no electricity is more a process issue, right? So when a developer initiates a development, by the time they sell the first property, they have to register a sectional title register with the deeds office, right? And from the date that they sell it, there is officially now a body corporate. So this body corporate, which is predominantly the developer, one would assume, depending on how many properties he's actually managed to transfer out, it appears to be derelict because there's no proper budget or plans or anything like that. So, you know, the fact that you're not paying the municipality gives me an indication that there's a bunch of stuff you're not actually doing that you need to be doing. So the non-electricity is actually a godsend to you in the sense that at least now you have noticed that there are issues. Because if you had electricity, but there was no maintenance, maintenance reserve or anything like that, you could actually land up getting to a point where you're in trouble because now you've got no money put away. How to sort that out? I would need to know how many people in the body corporate own properties there, where there's a way to do a body corporate turnaround, to have a conversation with the municipality quickly and go, listen, we as the body corporate actually have a quorum. We've managed to set up a new trustee board, and we're going to try and make plans. We're going to raise special levies. We're going to sue the developer, so on and so forth, just to try and like nip this thing before it goes too far. Just demanding from the developer and hoping that his promises come to fruition is going to get you in deeper water. Because think about a real worst case scenario. You're speaking about having a generator that's not working. Real worst case scenario is you land up with a 3 million rand account to the municipality. No one's willing to pay it. Your special levies are way too high. No one's willing to put money towards it. You've got a bond. You don't want a foreclosure because there's going to be a judgment against your name, but there's no money to actually turn this thing around. So you want to nip it quickly so that you guys can actually try to get this thing resolved while the debt is low, while you can still charge a special levy, while other owners are still vested.
Okay, it's scary. I must say that way. I saw the question and I thought, wait, you know, yeah, it sounds like, I mean, nothing. The snagging is clearly not done right. It sounds like a groot gemors. That's my other favorite Dutch law term, groot gemors.
I've never heard of that one. I need to go back in the books and check.
Just trust me. That's why you have Afrikaans friends.
Do you know how many times on stage this last week and I said, "Hier gaat verkoop." I even started like twanging some of the words. Like I got very comfortable saying it. I'm not going to lie.
I'm impressed. I'm impressed. Hier gaat verkoop, mandement van spolie, al those things.